Hello and welcome back to SCC Masters. It's our second lecture on the SCC paper F4. Today we will finish our first chapter related to law. Yesterday we saw some basic differences between the type of laws, for example civil law and the criminal law. Today, before going into further details, we will see some additional points related to both of them. Okay, so in the case of civil cases, the burden to provide evidences rests with the person who suffered or the claimant, while in the case of criminal cases, the burden to prove is on the shoulder of prosecutor. Here, the prosecutor have to prove that the person is guilty for any crime. Here, in the case of civil law, the person who has suffered or the victim needs to prove that actually something bad happened to him, and he has to prove it on the balance of probability. For example, a court may consider the occurrence of an event was more likely than not if more evidences are indicating for its likeliness, while on other hand, in criminal cases, the prosecutor need to prove beyond the reasonable doubt that the person is actually guilty for any specific crime. So that's why more clear and stronger evidences must exist. In criminal cases, wrongdoers break any law instead of any contract. So it's a wrong done to the society, and that's why criminal law is also known as public law. In civil law, it's a right or duty of claimant or suffered party to go to the court and ask for compensation. Now it's up to the court. If they think that the defendant is liable, then the court may ask defendant to pay damages or or equitable remedy if damages are inappropriate. Okay, so let me briefly explain you the difference between damages and equitable remedy. In damages, the defendant pays something in a form of monetary terms. For example, if there was a contract of $500 between two parties and one party break the contract, due to which other party suffered the loss of $500, now the court may ask to defendant to pay this $500 to the person who suffered loss. The equitable remedy is more than the damages. For example, if you make a contract to purchase something unique, let's say it was a unique painting, and here the seller promised to buyer that he will sell this painting for 100 USD. But now after a specific time, the seller has refused to sell this painting. Let's say because an other person quoted him the price of, let's say, $5,000 for this painting. But according to the contract of first person, he has right to purchase this painting in 100 USD. Then in such a case where seller bypass this contract, paying the damages of 100 USD won't be fair enough, because it's actually worth more than these $100. So in such a case, A court may ask to defendant to pay equitable remedy instead of damages. A lot of case names are quoted in this course, but please remember that no marks will be awarded for remembering any case name, statute name, year, or any section number. In case of civil cases, we will frequently see these words, for example, plaintiff or claimant versus defendant. A person who has suffered the wrong is plaintiff or claimant, and the other person is defendant who did the wrong act. And if I talk about criminal law, then we have very little part related to it in our syllabus. Now in sources of law, we have judicial precedent as a modern source of law. Precedent is a decision or judgment of court of law which is cited as authority in future cases of similar facts. For example, once a court establishes what is the correct remedy in any specific situation, then subsequent cases with the similar facts will also provide the same remedy. And here we have one more point. The latest precedent will be considered as more valid. For example, any specific event has occurred in 17th or 18th century, and in the last few years the same event again happened. Now in 18th or 17th century, when that event happened, the court decided something and gave its decision. And in the last few years, the same event happened again, but now the decision of court is different than the previous one. So in such a case, the latest precedent will always be considered as more valid. Every judicial precedent consists of two parts. The one is known as ratio decidendi, which is the binding part of judicial decision, and the other is known as obiter dicta, and it is the non-binding part of judicial precedent. Okay, let's start with ratio decidendi. It is a Latin word and the meaning of ratio is reason, and the meaning of decidendi is of decision. So ratio decidendi means the reason of decision. Why actually court decided something? What was the reason? So this part of judicial precedent tells us the reason behind the decision which was made by court in any specific case or situation. And this part of judicial precedent is binding in later cases of same facts. For example, here is Mr. A, and Mr. A murdered someone, and court the court released Mr. A. So it was the decision made by court. But if I ask for the reason of this decision, then as a reason court said that Mr. A was an unsound person. So that's why court released Mr. A. Now, as an example, if Mr. B also murdered someone, and now Mr. B is asking in the court to release him too, because in the past court has released Mr. A in the similar case, because the facts are not similar as it was in the case of Mr. A, and court may decide that not to release Mr. B because Mr. B is not an unsound person. Okay, let's discuss some more points related to them. A ratio is the reason of decision. Like in the case of Mr. A, the reason was he was unsound person actually, so that's why court released him. So that was the reason of court's decision. A ratio is binding on future judges in similar cases. Now let's say here we have Mr. C who commit the similar crime, and the facts of Mr. C and Mr. A are same. For example, Mr. C is also an unsound person, then the lawyer of Mr. C can ask in court to release him because the court has released Mr. A in the past where the facts of the case was similar to Mr. A. So in that case, the decision will be binding on future judges in the similar cases. Okay, we have three concepts here: reversing, overruling, and distinguishing. Reversing. Higher court reverses lower court decision in same case. For example, this decision was made by High Court, in which the court released Mr. A, but the higher court or Supreme Court may ask to imprison Mr. C by reversing the decision of High Court. The president of any higher court is binding to the lower court, but the president of lower court is not binding to the upper court. So higher court can reverse the president of lower court if necessary. Overruling. Higher court overrules lower court decision in different cases, as we discussed. Distinguishing. Court avoids earlier precedent by distinguishing the facts. For example, if the facts are slightly different as compared to the previous case. Ratio is not binding if too obscure or unclear. Ratio is not binding if made without care. A ratio is also not binding if it conflicts with a basic principle of law. Ratio is not binding if it conflicts with European law, and ratio is also not binding if it is too wide. For example, it is difficult to link it with specific situation. Also, the ratio is not binding if made in inferior court, like the High Court precedent is not binding on Supreme Court. Okay, so in the end we have a summary of court structures, of criminal court structure and civil court structure, and many elements out of it we have already discussed in the beginning of our lecture, but here is a quick summary. Let's start with Magistrates Court. It is considered the lowest ranked criminal court whose deal with such a cases whose fine is below than £5,000 and whose imprisonment is less than or shorter than 6 months. And here you can see these are the top courts followed by inferior courts. This Crown Court mostly hear the serious kind of offences. Now in the bottom right corner you can see some signs here which will help you to understand its relationship. Such as we know a person can make appeal from lower courts to higher courts in case if a person think that during the decision making a legal mistake has happened, then he can approach to higher court. Let's see these signs to understand it in a more better way. Okay, here first of all you can see a straight arrow sign which representing appeal. Then we have a narrow dotted arrow sign, appeal by way of case stated. We will shortly see it. And then we have another sign, it is wide dotted arrow, committal from magistrate's court. Okay, so here on the top you can see European courts. These are considered as super supreme courts. And here we also have privy council. Let's see what is it. Okay, so if I talk about it, then it is the final court of appeal for certain Commonwealth countries. Now if I talk about the Commonwealth countries, then these countries includes mostly those countries who were previously the territories of British Empire. Okay, so if we see the second sign here, appeal by way of case stated, then it is an appeal to a superior court on the basis of a set of facts specified by inferior court for the superior court to make a decision. And at the last we have committal from magistrate's court. Now the committal proceedings are court hearing held in the magistrate court to decide whether there is sufficient evidence against an accused person charged with a serious criminal offense to order them to face a trial in a higher court, for example, Crown Court. And these magistrate courts also have some civil jurisdiction. For example, they also play some role related to family cases or enforcement of local authority charges and rates. And if I talk about the civil court structure, then here you can see the magistrates courts are also at the lowest level. And for the cases specifically related to the employment, we have employment tribunal. Any appeal can be made to employment appeal tribunal. Here we have Crown Court and County Court. In County Court, usually those cases are heard whose fine is below than £5,000, for example small claim cases or fast track cases whose fine is between £10,000 to £25,000 held in one day. The Crown Court usually deals with licensing, affiliation and etc. Okay, so we have seen the meaning of these signs, and we are also familiar with Supreme Court, European courts, Privy Council and Court of Appeal. And here in High Court we have three divisions: Queen's Bench Division, Family Division and Chancery Division. Let's see some of their roles. If I talk about Queen's Bench Division, then it mainly deals with common law matters such as contract law or tort. And the Queen Bench Division also plays a supervisory role where it supervises the inferior courts. It may also issue a writ of habeas corpus, which is an order for the release of person wrongfully detained. And if we talk about Chancery Division, then this division is headed by Lord Chancellor, and it deals with traditional equity matters such as trust, mortgages, disputed wills, partnership, company matters, etc. And at the end we have family division. It mostly deals with matrimonial cases, cases related to family properties, and proceedings related to children's, for example, adoption of children's, guardianship of children's, etc. So we have covered our first chapter, and in case you have any question then you may ask me please. Thank you.